All right, we're going to continue with the Human Rights Code of Ontario, and there were some really terrific questions on the discussion board by students on that, which we're going to get to in a few minutes. So, again, Human Rights Code and the application of that to employment is something that I could spend weeks talking about. So, we can't really take a deep dive into this, but we will do sort of a high level understanding of it. So, I'm going to give you some what you need to know, which is actually indicative by the questions that were formed. One of the things we want to know is that the Human Rights Code applies to workers in Ontario, provincially regulated workers in Ontario, and it applies to all aspects of the employment relationship. In fact, there might not even be a relationship in employment because the person wasn't hired. In other words, it regulates what might happen from the very beginning of the advertisement for the job to the interview process, what can be asked in an application, what can be asked in an interview, the promotion of an employee, the disciplinary measures that may be taken under what circumstances, up to and including the most severe form of disciplinary measure, which is termination. So the word discrimination, we must understand, is not in and of itself a bad word. It means to choose. And in employment, there might be ways to choose one over the other that is not prohibited. So for example, if I chose to give a promotion to an employee because I did it on the basis of seniority, that would not be prohibited. Why? Because seniority is not a prohibited ground of discrimination. Having said that, it prohibits discrimination that is both direct and indirect. And indirect discrimination, also known as constructive discrimination, means that the measure that's put in place it impacts a group of workers that would be considered a class of workers that would have what we call an adverse impact on that group of workers. Okay, let's back up. Prohibited grounds. What are the prohibited grounds of discrimination? I won't go over them. They're there on the slide. You've reviewed them. Everything from race to color to place of origin to religion, or what we call creed, gender, sexual orientation, sexual identity, marital status, family status, disability, of course, and even record of offenses. So what does it mean to discriminate someone on the basis of these prohibited grounds? It means we can't directly discriminate or indirectly. So if I have a requirement that my workers wear a particular hat, they work in the kitchen of Burger King and my uniform requires them to wear a hat in the kitchen that says Burger King. But a worker may not be able to wear that hat because they have a religious headdress that they wear, and so you don't hire them because they can't wear the hat. Well, the hat, first of all, we're going to find out, is it a bona fide occupational requirement that they wear a hat? No, it's not rationally connected to the ability to do the job, which is to work in a kitchen. So that would be an indirect form of discrimination on the basis of religion. Having said that, if the requirement of the hat is also a health and safety measure, so for example, I require the worker to wear a hard hat, that might be a bona fide occupational requirement. So you can see that the application will depend on the circumstances. What we're basically saying is these are the rules, that you cannot discriminate directly or indirectly on the basis of these prohibited reasons, but there are going to be exceptions in some cases. And we're going to get to the exceptions in a few minutes. You will also notice that sometimes you need to ask a question that may appear to be discrimination. So in an earlier video, I talked about the fact that the federal government says that we cannot hire someone who's not able to work in Canada. That means we need to know that the worker is able to work in Canada. So what if I have an immigrant applicant for a job? Well, it depends the question that I ask. I can't ask them about anything that would relate to their nationality or to their citizenship or to their place of origin. I can, however, ask this very clear question. Are you able to legally work in Canada? You can see that the answer to that question is what I need. It doesn't matter where they came from. It doesn't matter the place of origin or, frankly, their citizenship. So these are some of the details of how the application of the Human Rights Code would apply vis-a-vis prohibited grounds of discrimination. But there's also exceptions to the rules. And the main exception is that the reason we need to, the reason we need to ask the question, or we may appear to be discriminating on a prohibited ground, is that doing so is a bona fide occupational requirement. So bona fide is a Latin term. Can't finish the course without a little bit of Latin, which means in good faith. So what we're saying is this requirement that we require of this worker that may not have it is in good faith a job-related requirement. It is rationally connected to their ability to do the job. It's necessary for them to have it to fill a work-related purpose, and we cannot accommodate them without undue hardship to ourselves. So if I have a worker who has mobility issues or a disability that prevents them from coming into the workplace, but if they were able to get into the workplace, they could do the job, then as an employer, I might be required to accommodate them by changing the entry so that they can get in. I might be able to argue that it would create undue hardship. If I'm a corporation, I would be very unsuccessful, I think, with that argument. But perhaps if I'm a mom and pop small operation and this would cost, tens of thousands of dollars, then that would be undue hardship. But let's take another example. I'm hiring for a lifeguard, and the same person applies, but the person's disability also is the reason why they also can't fulfill the bona fide, in good faith requirements of a lifeguard. For example, they cannot swim, and the reason they cannot swim is because it's based on a disability. But swimming is a bona fide occupational requirement for that job, and it cannot be accommodated with or without undue hardship. And so in that case, even though it would discriminate someone from getting the job that has a disability, it would be a bona fide occupational requirement and an exception to the rule. So an employer has an obligation to accommodate employees unless that accommodation would cause undue hardship, and if it's possible. Here's one of the questions that was on the discussion board. It's looking for a false statement. Now, I have to say that the answer to the question, I think, is pretty clear, and therefore it's a good question. But if it were just to look at the three alternatives to the correct false answer, this would be a little too much detail of knowing the application of the legislation. So I don't expect someone to know what would be the proper accommodation for pregnancy. So something to keep in mind. This is, in other words, a little bit of a tough question. Really good question. I like the way it's been set up. It sets up a case scenario, and it requires the answer, the ability to answer, to be based on application. However, I do think that, the distinction between marital status and family status sometimes can be challenging. So I might provide some more differences between the answers so that the correct, clear answer is there. But otherwise, a really good format of a question. Here's another reason I say this: pregnancy. To discriminate a worker on the basis of pregnancy is that discrimination on sex? Is it a discrimination on family status? Well, technically, it's discrimination on the basis of sex, because only women can get pregnant. So if we're discriminating only people who get pregnant, we're discriminating very clearly biologically against women. But I can see how there could be confusion as to whether that's about family status. Really good question. Straightforward, clear language. Also a very good question. Nicely set up and terrific options, very well written. Super question. Application is required, and some clear understanding of the law in human rights would be shown and demonstrated by a student who answers the question. Very, very well done. So to wrap up this particular video, because I'm now going to move on after this to common law, and we're going to leave statutory law behind, the legislation, and we're going to head into legal principles of employment law that have been developed through the court system. So we're going to change gears in a minute. But before we do, I want to come back to some of the words that we talked about at the beginning, this concept of jurisdiction between federal and provincial, but also staying within public law before we move to public law for a minute. I want to take a look at the procedural aspects of public law. One of the ways that legal disputes in public law can be resolved is by way of tribunal, and these are specifically administrative tribunals. You'll remember that when we say administrative tribunal, we are definitely in public law. In other words, government is on one side here. Rules of procedural fairness, rules of natural justice would apply. What kind of tribunals would we see in employment? Well, if somebody is denied unemployment insurance or employment insurance benefits, they might appeal that decision, which is a government decision, and there would be a tribunal that would hear their case. This would be in the federal jurisdiction, so a federal tribunal. On the provincial side, we would see people go to a tribunal if they've been denied workers' compensation benefits and they're appealing that decision. If someone's complaint goes to the Human Rights Tribunal, that is an administrative body. And lastly, employment standards. If somebody is complaining about not receiving vacation pay or holiday pay or termination pay, there might be a decision that is appealed to a tribunal. On the other hand, some of these statutes create offenses. In other words, offenses that are either federal or provincial offenses, in which case there would be a trial, there would be a prosecutor. So somebody would be charged. Maybe that's a person, maybe it's a company that is charged, and there would be a trial in court. At the federal level, we would see, for example, that somebody who hires someone that is not able to work in Canada, that is a federal offense. And there would be a trial for a federal offense like that. There could be very hefty fines, and additionally, there can be jail time. So a person who hires someone that is illegal and cannot work in Canada can be subjected to a fine of up to $50,000 and up to 2 years in jail. Provincially, take a look at the Occupational Health and Safety Act. If a worker is injured on the job as a result of a violation of occupational health and safety, the employer can be charged, in which case this is a provincial offense. There would be a provincial prosecutor, there would be a trial, the accused person would be put on trial, and at the end of the hearing, At the end of the trial, the judge would make a decision, and if they're found guilty of a provincial offense under occupational health and safety, they could be subjected to a fine of up to $100,000 or up to 12 months in prison. If they're a corporation, the fines can go up to $1.5 million. So you can see that these are not private lawsuits. These tribunals and these courts are public law, because they do involve government, whether they are tribunal or because they are offenses.